To this week's episode of the Debt Hotline. We're really excited to have a special guest, Greg Anjewierden, join. My name is Hannah Locklear.
To this week's episode of the Debt Hotline. We're really excited.
My name is Hannah Locklear, and I am one of Solo's team members. And like I said, we're really excited to answer your questions this week, and we're going to dive in just a moment. But before we get started, I wanted to take a minute to introduce our guest. So Greg Anjewierden, he's a licensed attorney in the state of Utah. Greg, are you licensed in any other states, or is it just Utah?
Just Utah.
Okay, I hate that I'm saying just Utah because that's still a big deal. But yeah, Greg is a licensed attorney. He actually used to work at a debt collection law firm. So he used to make debt collection calls, and he has a lot of experience in this space, specifically in medical debt collection. And Greg owns a company called Debtbrief, which is a legal resource for people who are dealing with debt issues, who have been sued for debt. Debtbrief has all sorts of resources for people that can help you respond to lawsuits, legal documents, courses, and other educational information. Greg, do you want to take a moment and just introduce yourself and tell us a little bit about you?
Yeah, well, you kind of hit the high points already, but I'm Greg. My website is debtbrief.com. And if you go there, you can find things like court forms and, just information that will help you if you're being sued by a debt collector. And I do consultations as well for people that are being sued and basically teach people how to defend themselves from start to finish.
Okay, so can you tell us maybe a little bit about a couple of the services or resources that you offer on debtbrief.com?
Yeah, I do, work with Solo, so you can find links there to Solo's stuff, like the answer to the, debt collection summons and complaint, as well as the Solo Settle tool to help people settle their debts. But then I've also got other court forms that you can get there, different packages of forms that will help you not just answer the complaint, but then, what happens after that as you get through the lawsuit and try and take yourself to trial or get yourself dismissed. So the forms, and then also, like I mentioned, I do one-on-one consultations with people as well. And during those consultations, I can teach you, it's one thing to have the forms to do it and, read about it online, but to have an attorney explain it to you. So I'll meet with people and kind of explain the process and teach them all the steps that they need to do to fight back, take it to trial, or, negotiate whatever they need to do.
Awesome. Yeah. So as I mentioned before, so many resources available to you if you're being sued or you're dealing with debt. Even if you haven't been sued yet, it's not too late to resolve the issue. So definitely take action. I think that's the most important thing, is to be proactive. But with that, we wanted to go ahead and jump into our questions for the week. We've received a lot of questions beforehand regarding any sort of debt issues. Our topic for today is specifically how to get a debt lawsuit dismissed. And so I wanted to ask you, Greg, in maybe like 3 to 5 steps, how would you say, what are the best steps to take to get a debt lawsuit dismissed?
Okay, so first of all, you've got to find your basis for dismissal. And this is the one that I think that people have the hardest time with. So it's not a guarantee that in every case you can get it dismissed, right? So, but you've got to have a basis. Maybe they've done something procedurally incorrect. They haven't served you properly with the summons, or maybe they don't have enough, as you've gone in the case, they don't have the evidence to prove what they're claiming. If that's the case, then you're going to, find your legal basis. And then you're going to file a motion to dismiss, or it might be called a motion for summary judgment. I mean, that's going to differ, based on the state you're in. And you're basically going to tell the judge, here's why this case should be dismissed. Here's my legal reasons for the case being dismissed. And then hopefully the judge would do that. There's some other ways to get your case dismissed as well. One of them being settlement. So, if you use a tool like Solo Settle and you negotiate and you settle your case, then, as part of that negotiation, you're going to negotiate, well, if I pay you, you're going to file the paperwork to dismiss the case. So, if you can negotiate a settlement like that, then the plaintiff or the creditor will actually file the paperwork to dismiss the case. That's another method of getting your case dismissed as well.
Gotcha. So I think like the biggest takeaway that I'm getting though is if you've been sued, like the number one thing to do usually is just respond, like engage in the legal process. Even if you know that you owe the debt, ignoring it is not going to make it go away. It could actually lead to you owing more in the long run. You might have to pay like court costs, attorney fees, interest, and more money than you originally owed. So I think the big takeaway here is like just be sure to respond, and don't be afraid to engage. If you know you owe the debt, again, most attorneys will work with you to try to find a solution. If you think that the debt's invalid or fraudulent in any sort of way, definitely fight it, because you shouldn't be held liable for something that you don't actually owe, right?
Yeah, and let me add something to that. You say, well, what if you think, oh, I owe this? Like, what am I? Why should I respond? Sometimes you just need some time, right? Like maybe some time to get some more money, or some time to negotiate this. And if you file that answer and engage in the process, you've just given yourself several months, because this court process isn't fast if you're engaging in it. If you don't engage, they're going to boom, get a default judgment against you really quick. But if you're engaging in the process and fighting back, it's going to take months, which is going to give you A, more time to come up with some money, or B, more time to show them that, hey, look, I'm willing to fight this. Let's negotiate. They oftentimes will come down in their numbers the longer these cases drag on.
Gotcha. Well, yeah, I think every case is a little bit nuanced, which is why we wanted to hold this this debt hotline where you can submit your questions. We're also going to respond to a few live questions on the chat, so please go ahead and submit those if you're watching live. And yeah, we understand that each case is a little bit unique. So before we dive into your questions, I did want to put out a disclaimer that although Greg is an attorney and he has a lot of experience in this field, this answer that he may respond to your question with is not necessarily legal advice. It does not like form an attorney-client relationship between you and Greg. And it doesn't necessarily mean it's the right thing that you should always do in your case. But we're hoping to just get people pointed in the right direction, give them some answers to some basic questions and some general answers. And again, like I said, this doesn't form an attorney-client relationship. Don't take it as legal advice. But hopefully this legal information will be helpful for you as you try to decide what the best course to take is in your case. So that being said, we are going to try something a little bit new today, where I'm going to share some audio messages that have been submitted before the webinar started, or before our Q&A started. And so we want to just take a moment, and everyone watching live, please let me know if you can hear the questions. If there's any audio or visual issues, just let us know and we'll try to get those resolved, okay? So yeah, with that being said, I'm going to go ahead and get this audio started and answer some questions. All right. All right, so our first question is from Jessica.
Hi, my name is Jessica. I was informed this past Friday that there was a judgment put on me January 2015. I was incarcerated until October 2015 and never received any paperwork, never received phone calls. So I tried to reach out and contact the attorney on the court paperwork stating that I have a court date to garnish my wages in 3 weeks. When I called the number, it was like a call center and basically a debt collector. I was hoping to settle out of court, and they just wanted any money I had left over for groceries after my paycheck, and I couldn't commit to that. So what should I do?
Okay, I'm not seeing any issues in the chat. So yeah, Greg, what are your thoughts?
Okay, I have a few here. This is kind of like one of those, like, this is kind of an interesting issue, right? It's kind of like a law school exam question where you got like a lot of different moving pieces here. My first thought is, and this is really common, where people find out they have a judgment against them and they're getting their wages garnished, and this is the first time they're learning about that. So in order for someone to get a judgment against you, they have to serve you with a summons and complaint to start the case, right? And it sounds like this person wasn't adequately served because she was in jail, right? Now, there's other ways that you can serve people, and a lot of times that the creditors will do some shady things to try and tell the court. Sometimes they'll just straight up lie and say, hey, we served this person, and the court will enter a judgment. So what I would do if I've got a judgment against me and I was never notified of the lawsuit is I would file a motion to set aside the judgment. And what I'm going to say in that motion is that it looks like I've learned of this judgment, but I was never notified of the lawsuit because I never received a copy of the summons and complaint. And had I received that, I would have responded. So what I'm asking the court to do is to set aside the judgment, basically throw it out and start the case over from the beginning, where I can file an answer and defend the case. In this person's case, they were in jail, and every state is going to have a procedure for serving somebody in jail. So they've got to go through this process. So it should be easy to go into the court and file this motion to set aside the judgment and say, hey, I was in jail at the time of this judgment, so I was never served in jail. They didn't go through the process to serve somebody in jail that they should have. Hopefully, the court will grant that motion, throw the judgment out, and start the case over from the beginning, giving you more leverage to negotiate, giving you the ability to defend yourself, etc. So that's what I usually recommend to people if they have a judgment and weren't aware of that being entered against them. Another thought that I have is, we're talking a judgment in January of 2015. This person didn't say what state they're in, but judgments can expire. They don't necessarily last forever, depending on the state that you're in. 10 years is a time period where certainly judgments will expire in less than 10 years in some states. Now, so, I would probably do a little research to see, in my state, can a judgment retire or expire, in that amount of time? And I might go to that hearing and argue to the judge, hey, I think this judgment has actually expired, so they shouldn't be able to garnish my wages. The last one is, she's already tried to negotiate a settlement. They won't do it. What I would recommend is show up to the hearing being ready to make these arguments, but try and negotiate right there before the hearing starts. Because I can't tell you how many times I've tried to negotiate a settlement, haven't been able to do it. But when I show up face to face and there's an attorney there, not just the lowly person in the call center, that attorney is almost always much more likely to make a deal with you. So I would go to that hearing and try and catch the attorney before the hearing starts and try and negotiate a deal right there. If you don't win on any of this, if the court lets them garnish your wages, that's not the end of the road. You can still negotiate a settlement even after they start garnishing your wages. So, don't give up. Sometimes it just takes some time to get these, settlement negotiations done.
Awesome. That's a great answer. I went ahead and dropped some resources in the chat. One is a blog post from solosuit.com about how to file a motion to set aside judgment. Again, this is a common issue if you've been sued and you were never served the documents, you never even knew about the case for whatever reason. You can request that the judge reverse the judgment and maybe try to engage in the lawsuit again and defend yourself. There's also another resource I'm adding here about how long does a judgment last. Like Greg was saying, judgments do expire, so they can't last forever. And if the attorney doesn't take further legal action to collect the debt, if they have a judgment against you, then it can expire and they can run out of time to go ahead and do that. So check out those resources. Maybe they will be helpful for you in your state.
Let me ask you, at Solo, do you guys have a form motion to set aside judgment? Do you guys have something like that?
That's actually a great question. So we actually have an AI bot trained called Solo Pilot. And this AI bot has passed the bar exam. And so it knows a lot about the legal process, specifically for debt collection cases. And you can use it to create any sort of legal document, including a motion to set aside judgment. So if you head over to solosuit.com, you can get that process started. It only costs $10 per document to generate that. And again, this is a very trained artificial intelligence that can help you be very confident that the document you're using will be held up in court for your state, and it'll be taken seriously. So yeah, check that out on solosuit.com. I'll drop a link in the chat where you can go over there and get the process started. And then, yeah, we'll move on to the next question because we've got a lot of questions tonight. I want to make sure we can get into as many as possible. I'm going to go ahead and share. Next question is from Donald. Let's go ahead and get that one played. And again, if there are any audio issues, please let us know.
Good evening, Donald Berger. The question is, I was served papers suing me for $22,000 by an attorney whose debt I really wanted to dispute, but I was under heavy medication and not cognizant to be able to respond to the 30-day limit that they imposed on me, and certainly couldn't read the papers and analyze what had to be done. And so we're in negotiations with the attorney. The question is, if there's solid defense against the bill, what kind of choices might I have or actions can I take, considering my extreme disablement? Thank you.
All right, Greg, any thoughts?
Okay, a couple. He brings up a couple of different issues here. The first is, hey, I don't know if I can respond within the 30-day limit. I mean, you got to file something, right? Like, if you file nothing, they're just going to get a default judgment. And like, that's kind of a tough position. But even if you can get a friend or a trusted family member to help you get something filed, you know, I think doing it on solo is a really easy process, but you got to get something filed by then or you're in trouble. You know, you can negotiate extensions to file things, right? So if you're like, I'm not going to get it done by this 30-day deadline, but you call the attorney. I mean, us as attorneys, we do this all the time. Like, I'm just busy. I couldn't get to this deadline. And we just negotiate, hey, I know it's due in 30 days. Can I have 45 instead of 30? And then we just, you know, you can either file a stipulation with the court showing that, or, you know, if you trust them, you can just confirm it in writing over email or something like that, and you can get yourself a little extra time. But if you can't do that, like, you just got to get something filed, even if it's just a simple, like, I deny everything, file that, and then do like a more full-blown answer later. The second was, if I've got solid defenses against the bill, you know, what do I do? Well, you got to go through the lawsuit process, right? So you're going to file that answer. And then what I would say is you're going to start gathering your evidence, present your evidence to the other side so that it doesn't surprise them. The court usually won't let you surprise with evidence later. And then I would send like a set of discovery requests. I've got sets of those up at debtbrief.com. And start, you know, sending them information so you can get information back about what they have, and then prepare yourself to present that information at trial, and, you know, make those arguments to the judge and hope that the judge rules in your favor if you really do have those solid evidence. I mean, there's a lot more to it than that, but, you know, I think that's kind of the basics as far as, you know, how I would describe it in a, you know, Q&A session like this.
Awesome. I dropped a link to debtbrief.com if you want to check out some of those resources that Greg was mentioning. And again, for sake of time, I'm just going to keep going through these questions to get to as many as we can. Our next question was submitted from Michael Somerville. I'm going to go ahead, and I'm a little concerned that maybe the voice, let me just double check on one thing on this video.
Yes, my name is Michael Somerville.
Oh, no, we're good to go. Okay, I'm going to go ahead and share, and yeah, again, let us know if any issues in the audio, please.
Yes, my name is Michael Somerville. I'm currently being sued in the state of Indiana. and by a debt collector, which is also a title loan company. I took out a title loan in August of 2022, and I basically want to know. They never tried to use the car that they use for collateral. They never tried to take the car, but they just went straight into suing me. And I'm wondering, can I use that car to have the debt taken away? Is that an option, or is it up to the debtor if he wants to take the car or not? Thank you.
Greg, were you able to hear that?
Yeah, I heard it.
Okay, perfect.
Okay, so when you're dealing with issues of collateral on a loan, a lot of this is going to depend on the terms of your actual contract. So it's probably a little bit, I wouldn't necessarily rely on what I'm about to tell you because I haven't reviewed the contract. Right? So, like, in some cases, the contract's going to allow them to just come take the collateral, and it may be that they just haven't done it yet. Like, that could definitely still be coming, right? As far as, like, can you use the car to try and, pay off the debt? Again, that's going to depend on the terms of your contract and what you're allowed to do. But certainly, when you're dealing with collateral, the idea behind collateral is, yeah, that property can be used to pay off the debt. So, I guess that's kind of it depends. Look at the terms of your loan agreement, and that's really going to depend on that. And it may be that you can use that collateral as a negotiation too. Like, if they get the car back, maybe they'll drop the suit, depending on what the value of the car is and how much is owed and things like that. I mean, that can all be used as part of a negotiation, certainly.
Awesome. Okay, you know what? I think we're going to shift gears a little bit and respond to a couple of the questions in the live chat, because we've got lots of people watching and want to get to some of those live viewers. So, first question comes from Carolina Skies. It says, I have court next week with LVNB funding. I submitted my answer, but wish I had added that I would like arbitration. Is it too late?
Okay, so maybe not, but it doesn't hurt to try, right? So, and this is going to depend. The law can be different in every state, right? Some states are going to say, yeah, arbitration. If you want to do that, you've got to do that early, or at least when you learn of there being an arbitration agreement. So it's possible if you're like, oh, well, I've got trial coming up. Is it too late? The court may say, hey, look, we're all ready to trial. I'm not going to kick this out to arbitration now. But it doesn't really hurt you to try, right? File that motion to compel arbitration, and the judge may say, yeah, this has got to go to arbitration. Then you've got exactly what you wanted. And all you're really out is your time in preparing that motion. So I would say it might be too late, but if you think arbitration is a better route for you, I would certainly give it a try anyway.
So the next question is from Bob, and it's actually related to arbitration. Bob says, if I file a motion for arbitration, am I compelled to accept the arbitrator's decision, or can I still refuse it and go to trial?
So that could be a complicated question, and we would need a lot more facts there to answer that question. Usually, most states will have, as part of their statutory code, they'll have a law about arbitration. And in most cases, it's going to say, hey, like, you're bound by the arbitrator's decision there. And what creditors will do in a lot of those type of cases, and again, this is going to depend on the state, but they'll take the arbitrator's decision and they'll actually go back to the court, and they can turn it into like a court judgment. In a lot of cases. So, like, really, you can't. Now, there might be appeal possibilities where you can appeal that decision. It also might depend on the terms of your arbitration agreement. Some arbitration agreements might be non-binding, for example, or allow you to go to court after arbitration. Like, that depends on the language of the arbitration agreement. So, most likely you are stuck with the arbitrator's decision, but, there might be specific circumstances where you're not.
Yeah, and I just want to speak a little bit to the process of arbitration too, and just kind of give a warning. Like, yes, arbitration can be a powerful tool to, like, maybe get a case thrown out, because in many in many situations, pursuing arbitration is more expensive for the collector than it would be worth to just drop the case. So, yes, it can work, but in other instances, depending on what your credit card agreement states, you may actually be responsible for the arbitration fees, which can be quite expensive. So just be careful to read your agreement before you decide on arbitration, because you don't want to be the one ending up paying all the arbitration fees, and that doesn't guarantee that you're going to win the case. So it'd be a huge bummer if you end up having to pay those fees plus whatever the debt ends up being. So yeah, just be mindful, be careful, do your research before you file for arbitration.
Yes, and for smaller debts, arbitration can definitely work to get rid of it because they'll just walk away. The other pitfall in arbitration, besides the possibility of you getting nailed for additional fees, is that when you go to court, the other side, the creditor, in proving their case, has to follow the rules of evidence. And that means they're going to have to, especially if it's like a junk debt buyer, they're going to have to bring in a witness that has knowledge of the original debt and the original contract. And they're going to have to bring in somebody from the junk debt buyer who can testify that the debt was properly sold or transferred. And a lot of times, they're not going to bring those witnesses to trial, especially if they're out-of-state people. But when you go to arbitration, the rules of evidence don't always apply. And so you sort of lose the possibility that they can't bring witnesses because they can send an affidavit, they can do things by Zoom. And so that's another pitfall of arbitration that I think people aren't always aware of, that you need to think through.
Thank you for that. Yeah, I think a lot of the time people think motion or arbitration is going to get is going to be the end all be all answer, but yeah, you got to do your research and decide if it's best for your particular case. Our next question from the live chat is from Angelique. It says, if a debt has been written off by the original creditor, doesn't that mean that the original company filed taxes and considered this a loss? And as a result, the debt collector can't collect on that income?
So this is a very common misconception, and I get this question like almost daily, it feels like. And no, that is not the case. So writing something off is an issue with taxes, and it's their issue to deal with the IRS. It has nothing to do with whether you owe the money to that creditor or not. They can write it off and still come after you in court to collect the money. And then if they collect the money, it's their issue to deal with the IRS as to whether that debt was written off and now needs to be accounted for or whatever, but that has nothing to do with you. So it does not matter if they've written it off. They can still come after you for the money.
That was a wonderful answer. Thank you for clarifying. Glad to hear you get that answer or that question a lot and that you knew your stuff there, Greg. Greg, we're about half past the hour. I want to be respectful of your time and just see if you have maybe 5 more minutes to respond to a few more questions.
Yep, let's do it.
Okay, we can kind of go rapid fire on these as well. I probably won't comment in between. Next question is also from the live chat. It's from Doug. It says, I was sued by Discover in April of 2024, so last April, and I filed an answer. No action has occurred since. Yesterday, I received a notice of failure to prosecute. Does this mean that they may let the case drop? Should I just wait and see what happens or file a motion to dismiss or some other tactic?
Yes. So what happens is if the case sits for a long time and nobody tells the court, hey, we're ready for trial, the court wants to get those cases off the docket. So they will issue a notice for, what do they call it? Notice for failure to prosecute. So yeah, and usually they'll give them a deadline like 20 or 30 days or something to respond. If I'm the defendant, which the questioner is, I'm just going to sit and wait and see, because the court may dismiss your case in 20 or 30 days. Now, that dismissal is probably going to be without prejudice, meaning that they could refile the case later if it's still within the statute of limitations. But if they're willing to let it drop now, odds are they're probably not going to pursue the case. So what I would do is I would sit and wait and see if the court dismisses it. If they don't, then the plaintiff is going to have to appear and explain why they haven't done anything on the case. And depending on what they say, then I might file a motion to dismiss. But for now, I'm probably laying low and hoping that the court dismisses it within the next month.
Yeah, and I just want to say it could be that filing the answer is what maybe stalled the case. So great job in engaging and not ignoring the lawsuit. That's great.
Maybe they were looking for a quick default judgment and they didn't get it. And so it's like, well, never mind. We're going to drop it.
Awesome. Okay, next question was submitted before the live stream. It's from Oscar in Virginia. It says, is there more of a strategic method of a way to file my answer to a lawsuit where it may get dismissed strictly off of just my answer? Or are the answers just something that is needed to avoid a judgment and it doesn't matter what is really included in the answer? But there's always going to be a reply by the plaintiff or debt collector. Thank you for your time.
That's a really interesting question. I don't know that I've ever seen somebody put something in the answer that like that's the thing that got the case dismissed. I mean, like we were just talking about, sometimes all it takes is you file an answer and they're like, well, they're going to fight back, so we're going to drop the case. And that's all it takes. Definitely an answer can ruin your case. Number one, if you don't file one, you're going to get a default judgment. Number two, if you admit too many things in your answer, you're going to get a judgment against you. So it can definitely hurt you in that way. But I don't know that there's anything that I'm going to say in that answer that's like, well, that's the thing that wins the case. You know, I'm going to go put in that answer that I deny the allegations, hope that's enough to get them to drop the case. But then what really is going to win the case for you is engaging in the process after that and showing that the other side doesn't have the proof that they need to prove that you owe them money.
Awesome. Okay, gonna do a couple more questions, still rapid fire here. We've got a question from Edson in New York. It says, I received a letter from LVNV Funding stating that I'm being served with interrogatories under the rules New York CPLR Rule 3133. I never received that letter, and also I disputed this debt and I never received a response. They only asked me to undispute it in order to settle, which I don't want to do. How do I respond to this letter and send a response to the law firm?
So this person got interrogatories, but they had never received notice of the lawsuit? Am I understanding that correctly?
It sounds like they got sued and then they got served with a request for interrogatories, and then he disputed the debt. So it sounds like he responded.
Okay.
And then they asked him to undispute it so that they could negotiate a settlement and try to settle outside of the court system. But it sounds like he was never actually served with the interrogatories. They just told him that they were going to give him that.
Okay.
That's
okay.
what I'm understanding.
Okay, well, if that's the case, you know, if I get the interrogatories, I'm definitely responding to them by the deadline, because if you don't respond to interrogatories or other discovery requests, that failure to respond can be used against you and they can get a default judgment against you. So if he doesn't have them yet, you don't got to worry about it. But if you get them, you definitely want to respond by the deadline. As far as, they want you to undispute the debt and, you know, negotiate outside of the court system, that is a load of crap. Like, I definitely don't do that. Gone. So I think people sometimes think of like a settlement as, what am I going to pay? But if you get a real settlement, it has to be a two-way promise, right? So you'll promise to pay, but they've got to promise to do something in exchange for it to be a valid contract. And the thing that they're going to do in exchange is dismiss your case with prejudice. So I'm never going to agree to do something or, you know, withdraw my arguments or whatever. My negotiation is going to be, okay, we can reach a number that works for both sides, but in exchange, you're going to dismiss my case with prejudice. So if I'm understanding that question correctly, I'm not doing what that creditor is asking me and saying, I'll pay you, but in exchange, you're dismissing my case.
Okay, great. I think if it's all right with you, Greg, we'll end on one more question.
Okay.
I just realized we had another voice recording question, so I'm going to go ahead and play that. Let's see. Got to share the audio with Greg to make sure it plays properly. Again, everyone watching live, everyone watching live, let us know if there are any audio issues. This is a question from Matthew.
Hello, I was sued by Velocity Investments. I'm in Kansas. I was served in October. It's about $5,000. Filed my answer through solo suit pretty much right away, and we had a Zoom pre-trial in January. Plaintiff asked for continuance to provide documents of discovery. I said okay. We had another Zoom pre-trial March. Different attorney because of spring break, and they asked for more time, and I said okay. And our next pre-trial Zoom date is May 5th. I never received anything from plaintiff after I filed the answer and sent that to them, and that's been about 6 months. So I'm wondering at this next trial date kind of how aggressive to be if I still haven't received anything or they don't provide anything at this court date, should I ask for the case to be dismissed because of lack of evidence? Can I even do that at a pretrial? Just kind of where to go from here. Thank you.
Okay. I'm definitely not granting any more continuances for them because I don't know this, but I've done this enough time. I can't guarantee this, but I've done enough of these to know that they probably don't have evidence that they need on your case. And they just keep resetting these pretrial hearings in the hopes that you don't show up to the next one. And when you don't show up, they will ask the court for a default judgment. So you can certainly, if they're not ready, you can certainly ask the court to dismiss the case at the pretrial hearing. The court probably won't do it, but it doesn't hurt to ask. The other thing that I would do is I would actually send a set of discovery requests, including a set of requests for admission that basically you're gonna and requests for production of documents, and I'm gonna ask them specific documents that they have that will prove their case against me. And if they don't respond or they don't have those documents, then you can file your motion to dismiss the case because you have asked them for the specific things that they need to prove your case, and they have responded by saying, we don't have them. So, I think you probably need to take one more step to get to, I think you're thinking about this case the right way, but you need to take one more step and affirmatively prove that they don't have the stuff that they need by sending a set of discovery requests. And then I think you'll have them. I wouldn't agree to another continuance. I would definitely show up at that hearing. You can ask for dismissal. Not sure you'll get it, but it's worth asking.
Awesome. Well, Greg, thank you so much for your time. I just want to take a moment here at the end of today's Q&A to thank everyone for submitting your questions. Thanks to everyone who called in and submitted questions ahead of time. Thanks to everyone who watched live and submitted questions in the chat. We love to answer your questions and hear your experiences and stories. And I hope that you guys were able to learn something new and maybe get pointed in the right direction today. And lastly, I just want to emphasize that, obviously the ideal outcome in a debt lawsuit, if you do not owe the debt, is for the case to get dismissed and you walk away and you don't have to pay anything, right? However, if you do owe the debt, which in some and many lawsuits is the case, a lot of the time you do owe the debt, right? So if that's the situation that you're in, that the debt is valid. I think one of the best outcomes that you could potentially have is settling the debt outside of court. The case can still be dismissed that way, and there won't be like an official judgment entered in the case if you're able to settle and negotiate outside of court. And so I think for me that's probably the ideal situation. And at Solo we've interviewed thousands of people who are dealing with debt issues similar to the stories that we heard today. And we've learned that in many cases, the ideal outcome is settlement. So if you know that you owe the debt and you just want to resolve it, consider looking into that as an option. We can also help you negotiate to settle the debt. We have an online platform called Solo Settle, which is like a negotiation platform that helps you negotiate with creditors and collectors online. I'm going to go ahead and drop a link in the chat and share the link. Go over to solosuit.com. Again, the tool is called Solo Settle. It can help you get started on that settlement process and figure out a way to resolve the debt, get it dismissed without having to go through the whole legal process. So I think I know obviously it's easiest to get the case dismissed if you don't owe the debt, but if you do, I think look into settlement because it could be the best route that you could take. And then again, want to share Greg's website, debtbrief.com. This has also other resources that could help you as you're navigating your debt situation. Greg, do you have any last words or last thoughts before we close?
No, I just echo what you say. The biggest thing is engage in the process, use the tools like Solo and what I've got at Debtbrief to help you. And, if you need to negotiate a settlement and that's the best case scenario, that's what you do. But use the tools that, we've put together to help you fight back.
Yeah, don't ignore debt collectors. In many cases, they are willing to help you find a resolution. They're human beings too, so don't ignore them. Be proactive, respond. and use these resources that we shared today to help you through the process. Thanks so much again, Greg, for joining. For everyone who watched and submitted questions, thank you for being here. This was a great episode of the Debt Hotline.